See the money won't stay for your meal, getting on a piece of pie for your wife. Everybody wanna know how it feels.
Today's topic, writ jurisdiction, is of vital importance if you are practicing in High Court. This jurisdiction is exercised by superior courts and has direct bearing on well-being of the society. This jurisdiction is based on age-old principle. There is no wrong on the face of this earth which cannot be redressed under the constitutional jurisdiction of High Court, where no other remedy is provided under the law. Constitution, as we all know, is an act of extraordinary legislation by which people establish the structure and mechanism of their government and in which they prescribe fundamental rights and rules to regulate the motion of several parts. Constitution of Pakistan, like any other constitution, determines most desirable way of life of people of Pakistan and creates a government, organizes the government by creating the three principal organs of the state, that is the legislature, the executive and the judiciary, and defines their powers and duties and creates written boundaries for each of them. The topic though is very vast, but the scope of my lecture in the given time will comprise of: number one, meaning and origin of writ, development of writ jurisdiction in Pakistan, concept of judicial review, 5 kinds of writ under Article 199 of the Constitution of 1973, practice and procedure and drafting, and unwritten restrictions which restrict the relief under various precedents, and lastly, the limitation and concept of laches. Now, to speak more generally on the subject, I will start with a brief account of origin and development of writs and what it means. Writ means a written order by a superior court commanding the party to whom it is addressed to perform or cease to perform a specified act. Judicial Dictionary of Words and Phrases by Stroud defines the writ as: a writ is the process by which civil proceedings in the High Court are generally commenced. These are issued in the name of reigning monarch for doing or not doing some act or thing. In Blackstone's dictionary, it is defined as: writ is a mandatory letter from the king in parliament, sealed with his seal and directed to the sheriff of the country wherein the wrong is committed or supposed to be, requiring him command the wrongdoer or party accused thereto brought to the justice and complainant, or else to appear in the court and answer the allegations against him. In concise Oxford Dictionary, writ is defined as, inter alia, a form of written command in the name of sovereign, state or court, issued to an official or other person, directing him to act or abstain from acting some way. The practice and procedure of writs commenced in the 1st century by the Norman rule in England, historically a royal prerogative. The inception of writ jurisdiction lies within the era of William I, also known as William the Conqueror, the Norman King of England. Upon the start of William I, Anglo-Saxon judicial system also came into existence, and it brought along with it the concept of writ jurisdiction. Anciently, writ was nothing more than a written directive from a king, witnessed and bearing his seal, directed to a royal official or to an individual or group of individuals, ordering to do or refrain from doing a designated act. With the passage of time, the English legal system was redefined further, and with the dispensation of justice, judges were appointed by the king himself, and they collectively were known as the King's Bench. Judges in the King's Bench used to discharge the duties of the king in judicial matters and only served at his pleasure. Further evolution of the judicial system led to the birth of Court of Chancery in the 14th century. Court of Chancery was the first court empowered to issue writs independently to the Crown. The court still exists and is called the Chancery Division of High Court in England. The Judicature Act of 1973 abolished the Court of Chancery and other courts and consolidated superior courts which exercised the jurisdiction for issuance of writs. In 1753, the East India Company set up a Mayor's Court at Madras, Bombay and Calcutta, and then ran side by side with native courts which administer justice under the civil and criminal branch of law. In the Indo-Pak subcontinent, the presidency courts at Calcutta, Madras and Bombay were established by the Indian High Court Act 1862. The High Courts continue to exercise the power to issue prerogative writs within the limits of their respective original jurisdiction. They did not have the power to issue such writs upon mufassil courts or tribunals or to the persons outside the limit of the presidency towns. No other high court except these high courts were vested with power to issue prerogative writs under Section 45 of the Specific Relief Act 1877. But this was not made applicable to Lahore High Court, Sindh Chief Court and courts of Judicial Commissioner at Peshawar and Quetta. After creation of Pakistan and until we have our first constitution of 1956, Pakistan was being governed under the Government of India Act 1935. As it was originally elected, there was no provision conferring power of High Court to issue writs. It was in 1954 that a new section 2223A was inserted in the Act of 1935, which vested High Courts in Pakistan with powers to issue writs to any person or authority, including government. Article 233A read, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue any person or authority, including in appropriate cases any government with those territories writs, including writs in the nature of Habeas Corpus, Mandamus, Certiorari, Prohibition and Warranto. In 1956, Pakistan had its first constitution and Part 9 of which was earmarked for judiciary. Article 170 of the constitution dealt with powers of High Court to issue writs, and latent words, that is Prohibition, Mandamus, Certiorari, Habeas Corpus and Warranto were used in this article. In January 1962, the Cabinet finally approved the text of the new constitution. It was promulgated by President Ayub Khan on 1st of March 1962, which was to take effect from 8th of June 1962. It contained 250 articles divided into 12 parts. These Latin names of the writs were dispensed with in the Constitution of 1962 on recommendation of Mr. Manzoor Qadir Advocate, then Foreign Minister. Justice Fazl Karim, in his book Judicial Review of Public Actions, by honoring the work of Mr. Manzoor Qadir, main draftsman of the Constitution of 1962, who served as the chairman of the Constitutional Committee, which eventually formulated Constitution of 1962, wrote, and I quote, "The Constitution of Islamic Republic of Pakistan 1962 introduced presidential system of government in Pakistan, but what it deserved to be remembered for is what it codified the law of judicial review in its Article 98, and that I understand it is the original contribution of this branch of law. In doing so, not only did it rid the law of the Latin names, what is more important, it produced order and consistency, which the writ jurisdiction in England was lacking, and reducing itself to a self-contained proposition, a rare combination of skills of a legal draftsman and intellectual power of a great lawyer. Even in England, since 1938, these Latin names have been parted away, and the word for the writs now used is prerogative orders. The powers of judicial review is now a statutory power, and application for judicial review are governed by statutory rules. Then thereafter, we finally had the Constitution of Islamic Republic of Pakistan 1973. It provided constitutional remedies to protect fundamental rights. Part 2, Chapter 1 deals with fundamental rights of a person. This part is also called Heart of the Constitution, which provides right to life, liberty, equality before law, freedom of speech and expression, liberty of thought, belief and worship, culture and education, right of fair trial, etc. And it is exercised where there is no other remedy provided under the law. Words filing of writ or writ is not used in the Constitution. The word used are application by aggrieved party or any person. Article 199 of the Constitution confers wide powers of judicial review on the provincial high courts in Pakistan as compared to powers of Supreme Court of Pakistan under Article 184(3) of the Constitution. The power under Article 199 of the Constitution to the high courts are wider and varied. These powers cover more areas than mere enforcement of fundamental rights. It is clear from the language of Article 199 that jurisdiction of High Court is discretionary and is exercised by observing limitations laid down in Article 199 itself and on the principles and precedents which, though not provided in Article 199, are otherwise well recognized and practiced. Under Article 199, the executive, judicial and quasi-judicial orders of the person, as defined in Article 199(5), can be challenged on the ground of being violative of any law or rules, etc. On the other hand, Article 183 of the Constitution, the Supreme Court only interferes in cases of a violation of fundamental rights which are of public importance. Whereas there is no such restriction on condition provided under Article 199, this means the High Court can take cognizance of cases which discloses violation of any fundamental rights irrespective of whether or not it contains element of public importance or not. Regarding element of public importance, if you are interested, there are two judgments I will be referring which must be read by the youngsters. PLD 2012 Supreme Court 224 and the other one is I.A. Shirwani's case 1991 SCMR 1041. In 2012 Supreme Court 224, I had the honor to appear in Supreme Court and argued for 5 days, and it was regarding closing of BSL school because after 18th Amendment the schools were being closed, BSL basic schools all over Pakistan, and 5 lakh students were to go home. So this act was challenged and the Federation was not willing to continue these schools, provincial were not willing to take these schools. So this was challenged directly in the Supreme Court, matter of public importance, and this petition was allowed ultimately on the touchstone of Article 25A of the Constitution that measures must be taken first and children cannot go home and cannot be deprived of education. The power of High Court in Pakistan are salutary check on the mischief or arbitrary use of the power of government functionaries or public office holders. These are extraordinary powers known as extraordinary remedies. These powers are different from those powers of which High Court exercises under other laws like Civil Procedure Code and Criminal Procedure Code. Now my next topic is judicial review. What it means? Judicial review is a process under which executive, legislative and administrative actions are subject to review by the judiciary. A court with authority for judicial review may invalidate laws, acts and government actions that are incapable or encroaches upon constitutional prohibition. An executive decision may be invalidated for being unlawful, or a statute may be invalidated for violating the terms of constitution. Two classic examples of these cases of judicial reviews are in the cases of Federation of Pakistan versus Shaukat Ali Mian, PLD 1999 Supreme Court, page 1026, and the other one is Sardar Farooq Ahmad Khan Lagari versus Federation of Pakistan, PLD 1999 Supreme Court, 57. In these two cases, after 5 nuclear devices were tested by Pakistan, emergency was imposed and fundamental rights were suspended. And simultaneously, a Foreign Exchange Temporary Restriction Act 1998 was promulgated, imposing restrictions on opening of foreign currency accounts and freezing of existing accounts and converting deposits of overseas Pakistanis into Pakistani rupees at much lower rate. Two important matters for judicial review came before Supreme Court. One was regarding imposing of emergency, which was challenged directly under Article 184(3) of the Constitution by Sardar Farooq Ahmad Khan Lagari, and the other matter was challenged the Writ of Act of 1998. Petitions were filed before the High Court. The writ petitions were dismissed in limine. Intra-court appeals were filed, and those were allowed by full bench of the Lahore High Court. The decision was upheld by the Honourable Supreme Court with certain modifications, and it was held that the Act of 1998 was ultra vires of the Constitution because it encroaches upon right of a person to have property and use it. Whereas regarding the other case, Sardar Farooq Ahmad Lagari's case, the emergency was held to be valid, but suspension of fundamental rights was declared illegal and it was set aside. So judicial review is one of the checks and balances in the separation of powers. The power of judiciary to supervise the legislative and executive branches when the latter exceeds their authority. The doctrine varies between jurisdictions, so the procedure and scope of judicial review may differ within the countries. Judicial review is a doctrine according to which the courts are entitled, in the exercise of judicial power of the state, to examine and decide the questions A. of constitutional validity of any law, B. it is the result of primary or subordinate legislation, or B. of the constitutional validity or lawfulness of a decision, action, or inaction of a person, a body, in relation to the exercise of public function. The judicial power is the power to decide. That includes the power to interpret. The core function of a judge is to decide by applying the correct law to the facts of the case before him. This necessarily involves interpretation of law in order that it may be so applied. The term judicial review has not been defined or used in the Constitution of Pakistan, nor in India or in America. It has been used in English legislative instruments. In Civil Procedure Code Amendment number 4, Rule 2000, it is defined as a claim for judicial review means a claim to review the lawfulness of an enactment or a decision, action, or failure to act in relation to the exercise of public functions. According to Lord Buckingham, the judicial review is defined as a power of the court to see that public powers are lawfully exercised. And according to Lindley, judicial review is defined as no duty of the court which is more important to observe, and no power of the court which is more important to enforce than its power of keeping public bodies within their rights. Besides the supervision of inferior courts and tribunals, judicial review provides means by which judicial control of administrative actions is exercised. Now, before I take up the 5 kinds of writs, I would like to refer a few words about the writs by Justice M.R. Kiani, former Chief Justice of West Pakistan High Court. He was a great admirer of the writ jurisdiction. While addressing Sindh High Court Bar Association on 11th of December 1958, emphasizing the importance of this jurisdiction, he said, and I quote, "Mandamus and Certiorari are flowers of paradise, and the whole length and breadth of Pakistan is not wide enough to contain their perfume," and further stated, "God fulfills himself in many ways, and that we the judges are the humble instruments of his fulfillment." Writ jurisdiction is the modern manifestation of God's pleasure, and God's pleasures dwell in the High Court. Unquote. Regarding Justice Kiani, with permission of Mr. President, a few more words. As a judge and then Chief Justice, this is for the consumption of youngsters as well. As a judge and then Chief Justice, his speeches at various forums were widely covered by national press because of the rare combination of intellect, wit, courage, integrity he personified. His characteristic band of humor and witty remarks did not spare even the rulers. In the last 4 years of his life, he was considered as the most popular speaker of the country. A collection of his speeches have appeared in the form of various books like The Whole Truth, Not the Truth, Half Truth, and A Judge May Laugh, and Afkare Pareshan. Justice Kiani retired in October 1962 and could not make it to the Supreme Court because of his open criticism of the regime in power. In recognition of his work, the citizens of Lahore arranged a farewell reception in his honor, in which he was named as Lisan-e-Pakistan, which means the voice of Pakistan. In his reply, Justice Kiani said that this title was dearer to him than Nishan-e-Pakistan. Then he went on to say that his purpose in delivering such satirical speeches was to keep the morale of the people high in a period of gloom and darkness. In one of his memorable comments, he wrote, "There are quite a few, I quote, there are quite a few thousand men who would rather have the freedom of speech than a new suit of clothes, and it is these that form a nation, not the office hunters." Now I come to the 5 kinds of writs. The writs of mandamus and prohibition are defined in Article 199A, 1A, Roman 1. It reads 199(1). Subject to the Constitution, a High Court may, if it is satisfied that no other adequate remedy is provided by law, A. On the application of any aggrieved party, make an order, Roman 1, directing a person performing within the territorial jurisdiction of the court functions in connection with the affairs of the federation, a province, or a local authority to refrain from doing anything he is not permitted by law to do, or to do anything he is required by law to do. So mandamus and prohibition, though not written in this, but it literally, mandamus means we command, whereas prohibition means to stop or to forbid. The first part of Article 199, 1A, Roman 1, confers jurisdiction upon High Court to make an order directing a person performing functions in connection with affairs of the Federation, a province, or a local authority to refrain from doing anything he is not permitted by law to do, or order prohibition, commonly known as writ of prohibition. The second part confers jurisdiction upon the High Court to make an order directing a person to do something he is required by law to do. This writ or order is commonly known as mandamus. Mandamus literally means command. It differs from writs of prohibition and certiorari as it demands some activity on part of the body or person to whom it is addressed to do or perform a public duty. In other words, mandamus is a command directed to state officer or inferior court requiring performance of a particular duty specified therein. Describing the writ of mandamus, Supreme Court in the case of Secretary Finance versus Ghulam Safdar, 2005 SCMR 534 held, mandamus is a high prerogative writ of a most extensive remedial nature and is in the form of a command issued from High Court directing any person or subordinate court to do a particular act, and can be issued in cases where, although there is an alternate remedy, but such mode of redress is less convenient, beneficial, and effective. The requirement of this writ of mandamus is that the petitioner must have a clear right. The standards for issuing such writs were settled in the case of State versus Merajuddin in PLT 1959, Supreme Court 147. The case was under Article 170 of the Constitution of 1956. It was held that mandamus cannot be issued unless the petitioner shows that he has the right to compel the performance of some duty caused upon the other party. Thus, this writ can only be issued if the person has a legal right to performance of a legal duty of public nature and the authority against whom the writ is issued has a legal duty to perform the obligation. The main purpose of mandamus is to remedy defects of justice. It lies in the cases where there is specific right but no specific legal remedy for enforcing that right. Generally, it is not available in anticipation of any injury except when the petitioner is likely to be affected by an official act in contravention of a statutory duty, or where an illegal unconstitutional order is made. The grant of mandamus is therefore an equitable remedy, the exercise of which is governed by settled principles. Mandamus being a discretionary remedy, the application for it must be in good faith and for not achieving some indirect purpose. Acquiescence cannot be a bar to issue writ of mandamus provided the petitioner has a clear right which is being denied by some state functionary. The petitioner must satisfy the court that they have the legal right to performance of the legal duty as distinct from the mere discretion of the authority. Mandamus cannot be issued to enforce a contractual obligation. The only exception is where the facts are admitted. Similarly, no direction can be issued to the legislature to legislate a particular law. This is based on independence of the legislature and arises directly from the doctrine of trichotomy of powers. Now, coming to the writ of prohibition, which means to stop or to forbid, and is dealt with Article 199, 1A, Roman 1 of the Constitution, which I have already read. The Constitution commands that no judicial or quasi-judicial authority can exceed its jurisdiction, and it can be exercised only by an aggrieved person. A writ of prohibition lies to prevent inferior tribunal or court or authority from exceeding its jurisdiction or even from assuming jurisdiction which does not vest in it. It is a preventive remedy that can be granted only when legal proceedings are pending before the court or tribunal, and if the case is finally disposed of and the decision is given by such subordinate court, writ of certiorari will lie as a curative remedy to quash the decision. Inferior courts take up hearing of a matter over which it has no jurisdiction The person against whom the proceedings are taken can move the superior court for writ of prohibition, or an order will be issued forbidding the inferior court from continuing the proceedings. On the other hand, if the court or tribunal hears the matter and gives a decision, the party aggrieved would have to resort to writ of certiorari against the final decision. Judicial discipline of the highest order has to be exercised whilst issuing such like of writs. The distinction between mandamus and prohibition is that the writ of prohibition differs from the writ of mandamus in that while mandamus commands activity, prohibition commands inactivity. The basic difference between writ of prohibition and certiorari is that writ of prohibition lies during pending proceedings, whereas certiorari lies when act has been done and it is subject to final determination of the court. Now coming to the next type of writ, which is certiorari, which means to be certified. It is dealt under Article 199 1A Roman 2 of the Constitution, which reads, jurisdiction of High Court. Subject to the Constitution, a High Court may, if it is satisfied that no other remedy is provided by law, A. On the application of any aggrieved party, make an order declaring that any act done or proceedings taken within the territorial jurisdiction of the court by a person performing functions in connection with the affairs of federation, a province or a local authority has been done or taken without lawful authority and is of no legal effect. In all these three writs, certiorari, mandamus and prohibition, the application has to be of that of an aggrieved party, not otherwise. Grant of relief under constitutional jurisdiction of High Court was intended to foster the administration of justice and turns down orders which were manifestly arbitrary, capricious and suffering from misreading of record. Certiorari jurisdiction is based on the principle that wherever judicial jurisdiction is exercised by an inferior court or tribunal, it is in cases of abuse or excess of or are liable to be corrected by King's Bench Division of the High Court. In other words, the High Court as delegate of supreme judicial authority from sovereign is liable for keeping the inferior courts or tribunals exercising such jurisdiction within their limits. It is manifest from above that though writ of certiorari, a High Court is empowered to correct the errors committed by the inferior courts or tribunals, and on the other hand to annul acts or proceedings taken by inferior bodies without any lawful authority. The court issuing writ of certiorari acts in exercise of supervisory and not appellate jurisdiction. As regard the character and scope of certiorari will be issued for correcting errors of jurisdiction. Thus, the High Court is empowered to interfere in all cases of excess of jurisdiction, whether the person exceeding jurisdiction is a court, a judicial or quasi-judicial body, or a purely executive or administrative tribunal or officer, provided such body, authority or order is performing functions in connection with the affairs of federation, a province or a local authority. It is tried law that a writ of certiorari cannot be issued as a substitute of appeal or revision, as its scope is limited and circumscribed to the eventualities mentioned therein. Courts though show caution and rarely interfere, but where the decision is against the express provision of law or some patent illegality, the High Court can interfere and even can set aside concurrent findings or order passed in revisional jurisdiction by civil court. For this, the reference can be made to the case of Muhammad Anwar versus Muhammad Alias Begum, PLD 2013, Supreme Court, page 255, in which this criteria has been settled. The other basic judgment on the point is Rahim Shah versus Chief Election Commissioner of Pakistan and another, PLD 1973, Supreme Court, page 24. Now coming to the next writ, Habeas Corpus and Quo Warranto, which can be filed by any person, not necessarily an aggrieved person. Habeas Corpus means you may have the body or to produce a body or have his body. It is meant to remedy illegal detention. It is dealt under Article 199 1B Roman 1 of this article. It reads, on the application of any person, make an order directing that a person in custody within the territorial jurisdiction of the court be brought before it, so that the court may satisfy itself that he is not being held in custody without lawful authority or in an unlawful manner. There is inspired saying that says that the condition upon which God has given liberty to man is eternal vigilance. This means that people must have the necessary education and awareness of most cherished right, and he will have to assert it so that there is no invasion on his right. Issued to produce a person who has been detained unlawfully, illegally, or wrongly, whether in a private custody or prison by an institution. Although basic and fundamental human rights are safeguarded and are enshrined and guaranteed in the Constitution of Islamic Republic of Pakistan 1973 under Article 4, which says to enjoy protection of law and to be tried in accordance with law, which is inalienable right of every citizen, and under Article 9, which says that no person shall be deprived of life and liberty save in accordance with law, and under Article 15 regarding freedom of movement, yet it is common knowledge that minions of law have of late become accustomed of showing flagrant disregard of these provisions of Constitution. The writ of habeas corpus is used to secure the release of a person who has been detained unlawfully or without lawful justification. The article provides a process by which a person who is confined without legal justification may secure his release from his confinement. An application is made supported by affidavit. If prima facie grounds are shown, the court directs notice of motion to be given to produce the detainee in court on the day fixed, and if no explanation is given by the person who has detained the detainee, an order is made for his release. In Pakistan, there is no codified law of habeas corpus. Nonetheless, provisions are pari materia and akin to Section 491 of the Code of Criminal Procedure. The empowerment of Sessions Court to exercise this jurisdiction was welcome and provided quicker relief and less expensive remedy. Next is the writ of quo warranto, which means under what authority. It is dealt with Article 199, Clause 1, B, Roman 2, and reads, requiring a person within the territorial jurisdiction of the court holding or purporting to hold a public office to show under what authority of law he claims to hold that office. Any person can file this writ, and laches is not a bar for filing this writ, as the continuation of a person illegally holding a office can be questioned. The power conferred upon the High Court by this clause is to require a person holding or purporting to hold the public office to show under what authority of law he claims to hold that office. Eligibility and competence of a person to hold a public office or post can be questioned, and court can ask question that under what authority he or she is holding such office. The remedy under clause 1, subclause B, 2 of Article 199 is available only against a person holding or purporting to hold a public office, and is not available against the holder of a private office. The expression public office is not defined in 1973 Constitution. It was defined in 1962 Constitution to include any office of the service of Pakistan and membership of an assembly. That definition was not exhaustive, and in any case, the connotation of the expression public office is well known, and that perhaps explains the absence of definition from the 1973 Constitution. The definition of term public office has been adopted by the courts in Pakistan in Masood Hassan versus Khadim Hussain case, PLD 1963, Supreme Court 203, as an office created by the state by character or by statute when the duties attached to the office are of public nature. This was reiterated in the case of M.A.U. Khan versus M. Sultan, PLD 1974, Supreme Court, page 228. Burden lies on the relator who has brought this writ to show that the respondent has no right at all to hold a particular office, and he has to prove it as held in the basic judgment PLD 1963, Supreme Court 203, Masood al-Hassan's case. This criteria for this type of writ was settled initially in the case of Muhammad Khan versus Lahore Cantonment Board, PLD 1964, Lahore 125, under 1962 Constitution, wherein it was held a proceedings for writ of quo warranto is initiated to test the validity of an appointment of a public office, and a petitioner does not seek to enforce a right of his as such, nor does he complain of non-performance of any duty towards him. What is questioned is the right of the respondent to hold a public office, and he must not have his personal interest or say that this person holding the office is not competent and I may be appointed to that post, for this writ of quo warranto would not lie. The credential of relator are very important, and it must not be based on mala fide. This was settled by Honorable Supreme Court in Muhammad Hanif Abbasi's case, PLD 2018 Supreme Court, page 114, and Dr. Azizur Rahman Khan versus Government of Sindh and another 2004 SCMR, page 1299. And regarding the fact that he must himself not have an interest, there's a very good judgment of Sindh High Court, 2019 PLC CS, page 1050. Now, lastly, I will come to the procedure, practice and principles to be followed in high courts. And at the preliminary hearing, it is observed that the persons with less experience, when they come before the high court, they are questioned regarding maintainability, question of laches and so many other questions. So, these next topic would cover that what are the things that you should be conscious of while drafting a writ petition, so that you are not confronted with those questions, and you must know the basics regarding which this procedure is followed. So the basic thing is, when you draft a writ petition, you must know which parties are to be impleaded, because sometimes some authority of government is to be impleaded and only if official is impleaded, and then the youngsters face embarrassment in the court that they are asked to implead the party in the court. So in order to avoid that, you must know what should be the parties who are to be impleaded as respondents in the writ petition. Now, I start with that the writ petitions, the procedure is regulated under Civil Procedure Code, and this was held in the Hussain case versus Hussain versus Settlement Commissioner case way back in 1970. The citation is PLD 1970 Supreme Court, page 1. Now, you brought a writ petition, sometimes notice is issued, comments are called, report or para-wise comments, but they are quite distinct from written statement. In an eventuality, this practice is becoming very obsolete now. If a writ petition is admitted for regular hearing, you are bound to file a written statement. जो दावा दायर करना होगा. If you don't file a written statement, then it will be taken as if the contents of the writ petition has been admitted as it is. There are two judgments on this point. Nazir Ahmad Sabri versus MBR 2003 YLR 861 and Mehboob Saber versus MBR 2003 MLD 1361. In both these cases, it was held by the High Court that since the respondents, after writ was admitted for regular hearing, have not filed written statement, so they have admitted the contents of the writ petition as it is, and they have not controverted it, although para-wise comments were filed in that case, but those were not considered. Then next is that for filing a writ petition, there is no limitation. If you have not filed a writ petition within a reasonable time, then the concept of laches is introduced, that this writ is hit by principle of laches. Now, laches means unreasonable delay in asserting a claim. So, the courts in different judgments have said what should be a reasonable time. It has been considered as 3 to 4 months. But this principle of laches of lately is considered as not a principle of universal application, and if the cause of action is recurring, like payment of salaries, etc., then only on the question of laches the writ should not be dismissed. There are two judgments on this. In Umar Ba's case, PLD 2013 Supreme Court 268, and Taj Muhammad's case 2020 PLC CS 668. Although the petitions were filed lately, but it was considered that since there was a recurring cause of action, so the relief was granted. So facts and circumstances of each case has to be examined, and delay of 2 years was condoned because the party had a strong right. In the case reported in 2021 SCMR 1313, 2009 SCMR 177, and delay of over 1 year was condoned because equity leaned in favor of the petitioner in the case reported in 2005 SCMR, page 126. So it has been consistently held that if a person has a right, no court could dismiss the cause on the ground of laches if it defeated the cause or justice or will perpetuate injustice. So list cannot be decided on the question of laches alone. It has been held so in the case of Farzand Raza Naqvi versus Muhammad Deen, 2004 SCMR, page 400, where delay of 5 years was condoned because the petitioner had a strong case on merits. So since Limitation Act 1908 does not apply to the proceeding under Article 199, therefore an application for direction of refund of money illegally levied and recovered cannot be dismissed on the ground of limitation. This was held so in Pfizer Laboratories case, PLD 1998 Supreme Court, page 64. Now, High Court, while exercising writ jurisdiction, has no jurisdiction to substitute its finding with that of the inferior tribunal. It can only correct the defects. Then factual controversy, if there are controversial facts, that cannot be decided in the exercise of writ jurisdiction, and High Court cannot enter into inquiry or investigation of a disputed questions of fact which require recording of evidence. In such cases, the matter should be decided by the respective trial courts as provided under the law. Citation on this is Government of Pakistan versus Ghulam Nabi, PLD 2001, Supreme Court, page 415. The next practice that has been consistently followed, that object of constitutional jurisdiction is enforcement of an existing right. It cannot be exercised to create or establish a legal right. You must have a right in existence already, and that can be enforced through writ jurisdiction. Then if there is some alternate remedy provided under the law, this is bar for exercising writ jurisdiction. This question has been decided in innumerable cases. Provisions under clause 1 say that a High Court may make an order if it is satisfied that there is no other remedy under the law. The consensus of courts is that it is left to the discretion of the court to weigh whether or not an alternate remedy is adequate. The courts have further agreed that in some cases, even if alternate remedy is adequate but order is patently illegal, mala fide or without jurisdiction, the court can still interfere. The extraordinary remedy under Article 199 is not a substitute for ordinary remedy of a suit, and where the remedy claimed is in substance a remedy available under the ordinary law, then a suit and not the writ is the appropriate remedy. Where, however, an order is challenged in a writ petition and is decided on merits, suit on same question will not rise, because under Article 201, that decision will become binding on the court, in which if at all a suit is filed, which will bound to be dismissed. Now, next is that the person whose rights have been infringed would be called an aggrieved person in Article 199, and only an aggrieved person can file 3 types of writ that I've already explained: Mandamus, Prohibition, and Certiorari. For Habeas Corpus and Warranto, anyone can file the writ petition. The Supreme Court of Pakistan, in the case of Fazaldeen versus Lahore Development Trust, Improvement Trust, PLD 1969, Supreme Court 223, held that it is not necessary that such a right must be existing in strict juristic sense, but it is enough for the applicant to disclose that he had a personal interest in the performance of a legal duty, which, if not performed in a manner not permitted by law, would result in loss of some personal benefit or advantage or curtailment of a privilege or liability or franchise. Now, against whom the writ can be filed? The grievance of an aggrieved person should be against a person who is performing functions within the territorial jurisdiction of the High Court in connection with affairs of federal government, a provincial government, or a local authority. The High Court may direct such person to refrain from doing something he is not allowed to do by law, and may also direct a person to do something he is required by law, which a person is not doing or avoiding. A writ can be filed only against the state, and it is not maintainable against private individuals or corporations. State has been defined in Article 7 of the Constitution and says, in this part, unless the context otherwise requires, the state means the federal government, Majlis Shura, Parliament, a provincial government, a provincial assembly, and such local or other authorities in Pakistan as are empowered to impose any tax or cess. So, as far as public interest litigation is concerned, number of petitions are filed on daily basis. The criteria has been settled regarding public interest litigation. In the case of signal free corridor, case 2015 SCMR 1739 titled LDA versus Imran Tawana. The youngsters must read this case because it touches several other grounds which have been the moot point of discussion since the inception of Article 2A in the Constitution, that whether it is a ground norm of the Constitution or not, or whether it is a substantive part of the Constitution or not. This issue has also been decided in this 2015 SCMR 1739. Now, if the writ petition is filed to settle a personal vendetta, it must not be honored, and there is a bar to file constitutional petition against a matter which involves question of terms and conditions of service that is not maintainable under Article 199 subclause 3 of the Constitution. And regarding this, the basic judgment is 2007 SCMR page 54, which says that regarding terms and conditions of service or posting and transfer, no writ petition lies. Lastly, the suo motu jurisdiction. The suo motu jurisdiction can be exercised only by Supreme Court, and High Court has no power to exercise such jurisdiction. This has been recently settled in the case of Janzeh Malik versus Balochistan Public Procurement Regulatory Authority and others, 2018 SCMR page 414, and Mia Irfan Bashir versus Deputy Commissioner Lahore, PLD 2021 Supreme Court page 571. Now, if all these criteria are kept in mind, then you draft a writ petition that what are the shortcomings and on which grounds I can be knocked out. So that should be covered in the drafting of a writ petition. It has to be very simple, to the point, and you must state the facts first. And unlike the other, there's a departure for reading a writ petition. Like in Civil Procedure Code, you are required to state the facts and not the law. But here, since the question is mostly on the legal premise, so you can quote the law under which you are filing the petition. And also you should file the question of maintainability of the writ petition, and that if you are apprehending that you will pose the question, that should be covered in your drafting. It should not be too lengthy, because we have seen that some lengthy writ petitions, people lose interest in reading it. It should be precise, to the point, containing the facts and the law. So this summarizes, and I conclude my lecture and submit that powers under Article 199 should be daringly exercised in appropriate cases, as it is of great impact on the relation between the masses and the state, and in case where action is found unwarranted, exemplary cost should be imposed on delinquent officials. This I conclude my lecture.
Sir, बहुत शुक्रिया, बहुत extensive और बहुत knowledgeful lecture आपने deliver किया. Thank you, sir. अब questions and answers for
Dr. Sadiq Siddiqui साहब को
शुक्रिया, तनवीर खान साहब को शुक्रिया, अंसर नवाज मिर्जा साहब को शुक्रिया, बिशारतुल्लाह खान साहब को शुक्रिया, और तमाम यंगस्टर और सीनियर्स का बहुत बहुत शुक्रिया सर.
Assalamu alaikum, sir. Muhammad Suleiman. Sir, my question is, in Mehboob Ali Malik case, the judgment was penned down in 1960, Lahore, page 575, by the Honorable Mansoor Qadir. And his lordship used one Persian proverb that if the antidote is being brought from Iraq, the victim of snake bite will be dead. On the basis of this concept of writ jurisdiction was erected. And he further said, in order to invoke writ jurisdiction, we have to see two things: adequacy and efficaciousness of remedy. How, when we are drafting writ petition, how these two things, and what are those things which have to be looked at in order to maintain the writ petition? And my second question is, whether writ petition can be invoked against the illegal acts of armed forces or not.
So far as your first portion of your question is concerned regarding maintainability of the writ, so while drafting the writ, you should be conscious of the recent precedents under which this writ petition can be hit by maintainability. So you should be equipped with the case law, and you can file a writ petition, which is a more convenient and speedy remedy. And if you fail, you can still file a suit, but that there are certain restrictions, because if the writ is decided on merits, then you cannot file the suit because the decision will be binding under Article 201 on the Civil Code. Regarding the second question, jurisdiction of to issue a writ under Article 199(3), from 2015 onwards, there has been certain relaxation in it, and if the order or the act complaint is patently illegal, without jurisdiction, coram non judice, then the writ can lie. You can read the 2015 Supreme Court judgment, exhaustive judgment on this point, and recently some judgments on this point as well. Melafidi.
और का कोई क्वेश्चन हो काइंड सर आप
Would you please explain latches again for the youngsters?
Latches means that you should come to the court within a reasonable time. The limitation is not applicable in writ petitions. You can invoke the writ petition, file a writ petition at any point of time. What the court has considered is that it should be filed in a reasonable time, and reasonable time has been given as 3 to 4 months. If beyond that, then if you have a strong case in merits, then the judgments that I have mentioned, only then in exceptional cases court will interfere. But if you have been indolent, you have been sleeping over your right, and you have invoked the right quite late, then the court will not interfere, and the petition will be hit by laches. So laches is a principle where, although the limitation is not applicable, but if the jurisdiction is invoked after a certain period of time, that may be 3 to 4 months beyond that, then the court will not interfere.
माशाल्लाह बड़ा एग्जॉस्टिव आपका लेक्चर था, आपने समंदर को कूजे में समझ दिया। एक आपने रेफरेंस दिया विद रेफरेंस टू द रिट ऑफ Mandamus, Prohibition and Certiorari, a petitioner must be the aggrieved person. Whether there is any exception to this general rule with reference to
writ of three types of writs. The only exception that can be the public interest litigation, but there is very limited. The certain criteria that judgments I have referred that has to be fulfilled.
As pro
bono public.
Thank you.
Regarding the interference of provincial high courts regarding the federal institutions having operations in the various provinces, sir.
Sorry.
Sir, federal institutions operating within the jurisdiction of a province, we can seek this remedy of interference by the High Court.
Yes, because there is a judgment on this point 2010 PLC, in which this question has been examined, and it has stated that the federation works at different parts of the country, and the writ not necessarily to be filed in Assam or the High Court, it can be filed in other jurisdictions as well.
आपने एक डिफाइन किया है कि जो रिट पिटीशन की कॉज ऑफ एक्शन 3 to 4 months आमतौर पर रिकमेंड की जाती है, लेकिन सर ये प्रिस्क्राइब किसी जगह नहीं है। हाई कोर्ट रूल्स एंड ऑर्डर्स में क्या प्रिस्क्राइब फॉर्म में जैसे लॉ ऑफ लिमिटेशन हम अप्लाई करते हैं सिविल लॉ में, ये प्रिस्क्राइब नहीं,
ये किसी जगह प्रिस्क्राइब नहीं है, ये प्रेसिडेंट्स हैं कि व्हाट शुड बी द रीजनेबल टाइम, तो उसको जो उन्होंने डिफाइन किया है, इट कैन बी 3 to 4 months, बट द जजमेंट्स आई हैव रेफर्ड, it can, even a writ was allowed which was filed after 5 years because the person had a right and there was a recurring cause of action. So there is no codified law, they are not written anywhere, but these are the precedents.
Thank you, sir. There was confusion. Any other person? Sir, please.
Assalamualaikum, sir. Wait from Murray. My question is that in recent times we are actually witnessing a change in climate, and there have been numerous environmental rights violations. So can I personally file a writ regarding some environmental rights, because they are not specifically enshrined in the Constitution. However, they can be linked to the right of life, but there is no codified way in which I can go for it. So can there be any precedent which can help me? Second, my question is, can court direct any governmental officer which are in or any private entity which are creating some housing society, like cutting down some trees, so that also amounts to environment, damaging the environment, without actually following the EPA code and PIPA. So can you guide us about that?
You being the resident of Murray, I know where you're coming from. This under Article 9, the right to life, you are a aggrieved person, because it is curtailing the right to life. So you can file a writ petition, and if you can overcome the criteria set by Supreme Court regarding the pro bono litigation, you can file in that capacity as well. And there is a pending matter regarding the cutting of trees in Murray in Lahore High Court Development bench, and this has been filed by the residents of Murray, and the High Court has taken cognizance of the matter. So in a term, you are a aggrieved person. मरगरा हिल्स केस वो सुप्रीम कोर्ट में भी चल रहा है, यहाँ पे भी चल रहा है जी, शैला ज़ियास जी।
सर बहुत शुक्रिया।